We have Mr. Love. Your Honor, we're going to ask the court to docket this matter for a trial. I'm going to suggest to the court, though, I think this is one where a final status comes beneficial. As the court, I think, is well aware, there's some matters in Otsego. They represent the more serious charges. We're still trying to work on getting those resolved, but I think we're kind of at the point where we probably need to docket this and we're either going to get a resolution or we're not. But again, I kind of believe that Otsego is where that all starts.
Okay. Ms. Koch, how time do people need to be ready for trial?
30 days.
Likewise, I would just ask the court, I suspect the court's setting further out 30 days, but no particular time frame needed.
Okay. So I'll put next available date, but I would expect at least 60 to 90 days. How many days of trial, Ms. Koch?
1.
I would agree.
1 day. Jury trial?
Yes.
Okay, with that final status conference on the motion day prior to the trial dates, that'll be the plea and motion cutoff. Ms. Koch, any other dates that we need to set?
No.
Mr. Trush?
No, thank you.
Okay, so Mr. Love, you and Mr. Trush will get notice of that final status conference and the trial date. It's important between now and then that stay in touch with Mr. Trush. Ready to proceed. Okay.
Yes.
Do you have any questions?
No,
Okay. Versus Nicholas Fennell, case number 255455.
Judge Mike Flagstead on behalf of Mr. Fennell.
Here, Coke on behalf of the people.
Mr. Flagstead, how do we proceed on this?
May I approach, Judge?
Yes.
Mr. Fennell was accepted into Otsego County Sobriety Court and is currently participating in the program. Given that, Judge, we do have a resolution whereby my client will be pleading to an added count of operating while visibly impaired third. With that understanding, he's been accepted into the Sobriety Court.
That's a correct statement of the offer. I do believe he is being accepted. There is no reduction. This is a 4th.
Mr. Fennell, have you had a chance to talk to Mr. Flagstead about this plea agreement?
Yes, sir.
Is that how you want to proceed today? Please solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God. Lower your hand. Mr. Fennell, are you currently on any kind of probation or parole?
I see it going.
Okay. Is your probation agent aware that you're entering this plea today? Yes. Are you going to face any penalties for violating your probation?
Not really. I believe so. She's well aware of the situation.
You understand that that is a possibility? Okay. And then by pleading guilty to the charge in this case, the maximum possible penalty you face would be up to 5 years. You understand that? Yes, sir. With that in mind, what is your plea to that charge today? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have a prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during the trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights? Yes, sir. You understand that you're giving up and waiving all of those rights by pleading guilty? Yes, sir. Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty? No. Has anyone promised you anything other than what we've talked about here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are actually guilty of this charge?
Yes, sir.
This happened back on June 6th of this year, is that the correct date?
Yes, sir.
On that date, had you been consuming alcohol?
Yes, sir.
And did you operate a vehicle on Old 27 North here in Crawford County after consuming that alcohol?
Yes, sir.
Did you have any blood or breath tests to determine the level of alcohol in your system? Do you know what those results were?
I remember my roadside numbers on the breathalyzer were 0.167, and I can't remember exactly what my blood test results were, but I have no doubt that they were high,
Okay. Over the 0.08 limit?
over the 0.16.
Okay. And do you have any reason to doubt the accuracy of those tests?
Yes, sir.
Had you consumed enough alcohol that you believe that your ability to safely and normally operate that vehicle was impaired?
Yes, sir.
Had you previously been convicted of operating while impaired back in 2017, 90th District Court?
Yes, sir.
And of operating while intoxicated in 2021, 87A District Court?
Yes, sir.
Hope you're satisfied with the factual basis.
I am. I do have a procedural question.
Okay.
Because they changed the way we do the sobriety courts with, at Seago, there'll be a full transfer. I know that, Mr. Clark did the MOU that we need. Will the sentencing be here or will it be sentenced up and at Seago?
The sentencing?
Yes.
That would still be here.
Okay, thank you.
Mr. Clagstead, are you satisfied with the factual basis?
I am, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
I am not aware of any threats, promises, or inducements beyond what's been placed on the record, Judge.
No, Your Honor.
Are you both satisfied that the court has complied with statute for rule in taking this plea?
Yes, Your Honor.
Mr. Fennell, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support the fact that you are guilty of this charge. The court will accept your guilty plea. We'll set this for a sentencing hearing. You'll be notified of the date and time of that hearing as well. Mr. Clagstead, it's important that you stay in touch with him between now and then. Also, before you leave today, you're going to meet with probation officer to set up a pre-sentence interview. Clagstead, anything further on this file today?
Where should be probation officer?
And then Mr. Haven, right after court.
Judge, I do have a draft MOU, which Ms. Koch has already seen and the people at Seago have already seen. I'm sorry, the sobriety court people have seen. Are you interested in looking at that now? Possibly even signing now or no?
I think that's something I would sign at the time of sentencing.
Okay.
So you can just bring a signature copy at that time. I don't need to review it prior to that.
All right, Your Honor, thank you.
Okay, thank you.
Okay, I'll give a copy of that.
Mr. Truce, are you ready on Mr. Castle's case?
We are.
Called People versus Castle. This is file number 255481. Record should reflect that Mr. Castle is present here in the courtroom today. I guess counsel with your.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Castle.
Okay, the record should reflect I did meet first with counsel prior to court today to disclose a third party communication I had received in my personal email. Familiar with Mr. Castle and was, I think, submitting a support letter on his behalf. I disclosed that letter, its contents, and the fact that I had received it through a personal communication with counsel. Ms. Koch, do you have any objection to me continuing to preside over this case?
No.
Mr. Church.
I have no objection.
Okay. Mr. Castle, did you have a chance to go through the pre-sentence report and talk to Mr. Church about that?
Yes, Your Honor.
Okay. Mr. Church, are there any additions, deletions, or corrections to that?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Koch, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, this is an appropriate case for HYTA. We're giving Mr. Castle a great break by dismissing one of the cases and offering that as part of the plea. We hope the court accepts that. He's 20 years old. He has no felony or misdemeanors. He not only did he make a mistake once, he made it twice and very close together. I have no idea what was going on with him or what he had going on with this situation. You know, he tried to evade the police officers. He had a ski mask under his seat. He had marijuana in the car. They had to break into the safe, but he was cooperative with the police officers in the first case, and then we had this case shortly thereafter. I hope that he learned his lesson from this, because having 2 police contacts in this circumstance, 2 felonies, is a bad way to start at 20 years old. And if he continues this, we're going to be seeing a lot of him. If he takes HYTA seriously, this court gives him that opportunity. Hopefully, the only time we see him is in the community, being a productive member of society. So I really hope that, I know sometimes youth at this age don't understand what a benefit HYTA is. I hope he takes this seriously. Thank you.
Mr. Truce, anything on behalf of Mr. Castle?
Yes, Your Honor. You know, the prosecutor correctly identifies, I think Mr. Castle is a good candidate for HIDA. You know, the circumstances here, I think, are a little more nuanced than the prosecutor gives them credit for. There are 2 offenses that happen close together, but there is a distinct difference between the 2 offenses. And I think it's very important what it is. He stopped the first time and he's transporting knives. And again, he recognizes after being arrested, I don't think he did at the time, but he recognizes that that's illegal. What he does is try to take corrective action for it. The corrective action he takes is he stores the knife in a locked box. Arguably, that may be a legal way to transport it. I say this because if somebody came to me and asked me, how am I supposed to legally transport this in a car? I think the answer I would probably give them is to lock it up in a safe. Again, I think there is an important distinction between the 2 offenses in that he tried to take corrective action. Again, I'm not going to necessarily say that it's the correct action or that he took the correct thing away from the first stop, but I do think that it does show that there is some reason to think that he has high rehabilitative potential there. Because again, it did change his behavior, just not necessarily the way we thought it would. With that in mind, he has no prior history. He's very young. I think that this is the ideal candidate that we're looking for with HIDA, because we have the opportunity to course correct from a path that, as the prosecutor said, you know, probably would lead him to be here more often. And, you know, every time he's here, it's going to be progressive sanctions, right? You know, probation, jail, to prison if he keeps down that path. I think HIDA is a great opportunity for him to course correct. And again, we see these cases, and I think overwhelmingly, they're not cases where someone wakes up and it's like, I'm going out to commit a crime today. And they're cases of either ignorance of the law or sometimes just sort of neglect in terms of properly transporting something. I think this is probably ignorance of the law, given his age and what happened here. But that would seem to me to be an appropriate case for HIDA to give him an opportunity to keep his record clean. Thank you.
All right, thank you. Mr. Castle, is there anything you wanted to say today?
No, everything sounds about right.
I read through the report. I'm familiar with you and your background generally from the information in that report. And I read the description of the offense and what took place that brings you before the court here today. And I take all of that into consideration along with what the lawyers had to say in that letter that I received on your behalf, or email, I should say. You know, first of all, I do think this is an appropriate resolution. I think a term of probation to kind of provide a degree of oversight and supervision to get you back on the right track, to keep you on the right track. You're a young man, 20 years old, right?
Yes, sir.
So you've got a long way to go, and the last thing you want is to be doing that with a felony on your record. And as Ms. Cope indicated, this youthful trainee status will allow you to have this come off your public record, probation. And as you're gonna find out if you haven't already, that's really important for jobs, school, all kinds of things. I do think that there's certainly indications that you could do well on probation, and you know, the goal here is to make this a speed bump, a learning point as you're coming out of adolescence and into adulthood, rather than a major obstruction. And I hope that that's the way this turns out. There's indications that you can make this a speed bump and move on. And so I hope that's what you decide to do. You know, I think there's some concerning things about what I've read in terms of the substances, certainly the weapons, but I think some sense regarding weapons. To me, that's less concerning than the substances are, and those things in combination.
Sure.
So please take this as an opportunity. If you need help, to get that help, to get yourself on the right track and to stay on the right track. Because
Absolutely.
you got a lot of promise, and I'd much rather see you live up to that than to go the other way.
Thank you, Your Honor.
And this is a real turning point in the road for you, making that decision. So I'm going to follow the recommendation and send you to probation for a period of 18 months pursuant to IDA. The court's going to adopt as the conditions of your probation all the terms and conditions that are listed in this report. So your agents can go through those with you. It's important that you understand everything.
Absolutely.
The court is going to order that you pay $130 in crime victims assessment, $325 in court costs, attorney fees, $350, DNA testing fee of $60 to $68 state cost, and supervision fee $30 per month while you're on probation. The court's going to order 2 days in the Crawford County Jail with credit for 2 days served. Because this is pursuant to IDA, there are no appellate rights at this time. But Mr. McFell, are you going to meet with him?
Yes, I am, Judge.
Okay, so just touch base with Mr. McFell before you leave. Going forward.
Thank you, Your Honor.
You see Mr. Walt?
Mr. Walt is in the Clare County Jail.
Oh.
I notified the prosecutor a little over a week ago, I
Yes.
think, and I believe they did a red.
Did a red, okay.
And 11:32.
Miss Cody, you can see your staff can touch base with Claire. I don't see them connected.
Okay.
So let's take a short recess and we'll come back at 2 o'clock. Okay, Mr. Walt, are you able to hear me okay?
Yes, sir.
On record in People versus Walt, this is file number 55477. The record should reflect Mr. Walt is present today by video from Bear County Jail. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Tristry on behalf of Mr. Walt.
How do we want to proceed today, Mr. Chair?
Thank you, Your Honor. We are in receipt of an offer from the prosecutor that contemplates if Mr. Walt pled to an added count 2 controlled substance possession of a narcotic less than 25 grams, the principal count would be dismissed. And that's MCL 333-740-3285. We would seek to take advantage of that today.
Okay, would we be taking the factual basis to the methamphetamine?
Yes.
Okay. Ms. Cope, is that a correct statement of the plea offer?
It is, and the maximum for that is 4 years and or $25,000.
Thank you. Mr. Walt, have you had an adequate opportunity to speak with your attorney, Mr. Trush, about this plea agreement?
Oh, yes, sir. Yes, sir. He's an excellent attorney. Yes,
Is that how you wanted to proceed today?
yes. Yes, it is.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I swear.
Thank you. You can lower your hand. Mr. Walt, are you currently on any kind of probation or parole?
No, sir.
And as Ms. Koch indicated, the maximum possible penalty you could face for the charge of possession of a controlled substance is less than 25 grams, is up to 4 years and or a $25,000 fine. Do you understand that?
Yes.
With that in mind, what is your plea to that charge today?
Guilty, sir.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want to. You understand all those rights?
Yes, I do. Yes, I do.
And you understand that you're going to be giving up and waiving all of those rights by pleading guilty.
Yes. Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. And that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. Do you understand that?
Yes, I do. Yes, Your Honor.
Has anybody threatened you with anything to get you to plead guilty?
No. No, Your Honor.
Has anybody promised you anything other than what we've said on the record today?
No, sir.
Is it your own free choice to plead guilty?
Yes.
Are you pleading guilty because you are in fact guilty?
Yes, I am.
The
Yes, I am.
information I have indicates that this happened back on July 1st of 2025. Is that the correct date?
Yes.
On that date, were you present here in Crawford County?
Yep. I was going through, I was on the freeway, yes.
Okay. And at that time, did you have possession of some methamphetamine?
Yes, I did.
Did you know that that's what that substance was?
Yes.
Did you have any legal right to have any amount of it at that time?
No, I did not.
All right, Ms. Koch, are you satisfied with the factual basis?
Yes.
Mr. Trush?
Yes, Your Honor.
Ms. Koch, are you aware of any threats, promises, or inducements other than what's been placed on the record?
No.
Mr. Trush?
I'm aware of none.
Counsel, are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Mr. Walt, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea as to the lesser charge. We'll set this matter for a sentencing hearing. Do you know how long Mr. Waltz could be in Clare?
So he indicated to me, I think he had his preliminary exam on the charges there this week. I did discuss with him whether he wanted to be brought here in person or not. I think he had indicated to me, and Mr. Walt, let me know if you feel differently, but I think he was okay with being sentenced via Zoom.
Okay, Mr. Wald, is that correct?
Yes, sir. If I may, I've been diagnosed. I'm sick. I have acute osteomyelitis that I'm trying to take care of, which is a serious bad bone infection, which is causing bone marrow cancer. So I have to go to treatments and stuff, and I have them set up here, down here in Clare County. So.
Okay. All right, so we'll set that for a sentencing by video. Between now and then, Mr. Wald, somebody from our probation department will be in touch with you for a pre-sentence report.
Okay.
And you'll have an opportunity to go through that with Mr. Trush prior to the sentencing hearing.
Yes, sir.
Anything further?
There is one more thing I want to address to the court, and I'm going to make a somewhat odd request. So I talked to Mr. Walt about canceling his bond here so he can earn credit. Unfortunately, I don't know if that's the best idea for us to do because he has his medical treatment set up through the jail that he's at. So if we revoke his bond, my worry is that what's going to happen is when they take him to get his medical treatment, they're going to not let him go because there's a hold from Crawford. So I just want to indicate to the court, I mean, for that reason, we're not asking the court to revoke his bond because I think it might prevent them from getting treatment. But otherwise we would be. I'm likely to ask the court to consider that he's been incarcerated this time.
You mean for purposes of credit and sentencing?
Right.
Okay. All right. I'm not going to make any decisions on that, but I'll note that may be an issue that you're going to raise as part of sentencing. Take that into consideration. Ms. Koch, anything further from your side?
No.
Mr. Wald, do you have any questions at all?
No, sir. As of right now, my bond is still, it's not revoked. So if they happen to let me out, I may be, the charges may be dropped here. I'm actually innocent here, other than resisting, but they're supposed, I would assume they're gonna get dropped here enough to be able
Mr.
to
Walt,
go.
don't talk about the facts of your case here
Okay.
or there because we are making a record.
Okay.
Yeah, so Mr. Wald, just make sure you stay in touch with Mr. Trush about what's going on with your case and he'll
Okay.
make sure that your bond status is addressed appropriately.
Oh, okay.
All right.
Thank you, Judge.
Thank you. The court's going to disconnect at this time. People versus Zachary Schlaff, case number 255472.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Trish Green on behalf of Mr. Slav.
Date time set for sentencing in this matter. Sir, did you have an opportunity to go through the pre-sentence report and talk to Mr. Trush about that?
Yes.
Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Koch, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation?
This isn't Mr. Slaff's first go around with the fleeing and eluding, which you can see in his criminal history. I think this particular chase went on for 8.9 miles. He didn't have a driver's license. He was driving recklessly. He's 30 years old. He doesn't have any prior felonies, but he has 6 prior misdemeanors. I think we had him last year. He had a drunk driving case. I hope that he learns his lesson. I mean, these type of situations where people are fleeing and eluding are really dangerous and a lot of times end with serious injury or even death. I don't know why somebody would take off and you took a 93-day misdemeanor of driving without a license and turned it into all of this. So I think this is poor decision-making, and I hope that he learns his lesson. I think the recommendation is appropriate, especially given that this is not the first time he's done this. Thank you.
Thank you, Mr. Trush.
Your Honor, so I think the prosecutor's recitation of his prior history is accurate. There's no prior felonies. He does have some misdemeanor history. I think we see these come up from time to time. What we see is it's sort of quicksand, right? He makes one bad decision, which is driving when he knows he shouldn't be. And then he's caught. Police show up and he makes a second bad decision. We all know driving a suspended driver's license is a non-serious misdemeanor. But he makes the bad decision of, instead of being pulled over and being arrested, he decides to run. It's not a good decision, and I agree with the prosecutor. These situations can be dangerous because they often at least start in areas that are residential areas or areas where there's people. With that in mind, the guidelines range here is small. The guidelines range here would suggest that a short sentence is an appropriate measure. I think for Mr. Schlaff, I agree with the prosecutor. He's got to make some decisions on where he wants to go with his life and what he wants to do. He does have the ability right now to go into a rehab. He's been approved and could go today if the court were to allow it. He's been approved through Bear River. I think that the recommendation here is well crafted as to both his history and what occurred here. I would ask the court to consider allowing him to enter a rehab program as part of the sentence here. Again, the guidelines range being 0 to 11 would still suggest at least that there's a presumption against upfront incarceration. I think that allowing him into a rehab setting is an appropriate middle ground there that addresses his needs while providing, to an extent, a punishment element to this. Thank you.
Thank you, Mr. Schlaff. Anything you wanted to say today? I read through the report, so I'm familiar with the circumstances of what happened here, and your background and your circumstances generally based on the information that reported to. And I would just echo what the lawyers had to say, which is a lot of bad decisions during the course of this incident. For better or worse, we're in a small town, and police kind of know whose licenses are suspended and whose aren't. And so it's not like you live in a huge metropolitan area where you can be sort of anonymous. So it doesn't make any sense for you to try and drive knowing that everybody knows you should be out there driving. So that's the first bad decision. And then of course you found that something that really didn't even need to be as bad as it was in the first place. And so for those reasons, while there is a presumption against jail time, I think jail time is appropriate given the danger that you presented to yourself, to other people, running in the way that you did, trying to flee. I do think a sentence at the low end of the guidelines, though, with some time held in advance, would address the need for punishment, but also give you that opportunity after 60 days in jail to seek out treatment. And I think that would be a good thing for you. And I think that's something that I hope you take advantage of, seek out, because I think that could help you with a lot of things, including decision making. The court is going to follow the recommendation to the extent that it is going to place you on probation for a period of 24 months. The court is going to adopt as the terms and conditions of your probation all the terms listed in this report. The court is going to order that you serve 60 days in the Crawford County Jail. I'm going to impose 6 months total. I'm going to order that you serve the first 60 days in jail with credit for 2 days served. I'm going to hold the remaining time in abeyance. So if you follow your probation, you don't have any issues while you're on probation, you never have to serve that additional 4 months. If you violate your probation, though, the court can impose any or all of that jail time needed. So again, that'll give you a chance to go to treatment in 60 days. Follow through with that. The court is going to order that you pay a crime victim's assessment of $130, court costs of $325, which attorney fees $350, $68 state cost, and $30 per month supervision fee while you're on probation. You do have the ability to seek an appeal of this sentence. And this, you have Mr. Schlepp acknowledge you have received it as appellate rights. Very good. Let's do the county consent. Mr. Baker?
Yep. You have other clients here in the courtroom?
I do not. Mr. Phillips and Ms. Harriman are both lodged in the Otsego County Jail.
Okay. Mr. Baker, if you come forward to the podium there, please. On record in People versus Benjamin Baker, this is file number 255439 and 5488. I guess counsel put your appearances on.
Sierra Coke on behalf of the people.
James Dick on behalf of Mr. Baker, who's standing to my right, Your Honor.
Okay, and Mr. Dick, can you tell me the status of these files today?
Yes, Your Honor, we have a resolution to each of the files. The older file, Mr. Baker will be pleading guilty to domestic violence with prosecutor's consent to 769.4A in exchange for a dismissal of the other charges. In the newer file, Mr. Baker will be pleading guilty to 1 count of resisting and obstructing in exchange for a dismissal of the original charge.
So I guess we need to clarify some case file numbers.
Sorry, my apologies.
So 5488, that's aggravated stalking, that's what we reduced to misdemeanor domestic violence.
No, that will be the one that is going to,
We're adding a count of R&O to that case.
Oh,
yes. My apologies.
that's all right. And so then in the other file, 5439, he'll plead guilty to count 5, which is the misdemeanor domestic violence.
Yes, Your Honor.
Is that correct, Ms. Cole?
It is.
Mr. Baker, have you had an adequate opportunity to speak with Mr. Dick about this plea agreement? Yes. Is that how you wanted to proceed today? Yes. Okay. Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Sure. Mr. Baker, are you currently on any kind of probation or parole? No. You understand that by pleading guilty to resisting or obstructing, that appears with the maximum possible penalty of up to 2 years or a $2,000 fine? Sure. And that domestic violence as a first offense is a misdemeanor that carries with it a maximum penalty of up to 93 days and or a $500 fine. You understand that? Sure. With those maximum penalties in mind, what is your plea to each of those charges today? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you here at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during the trial, and not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights. You understand that you're going to be giving up and waiving all of those rights by pleading guilty. Sure. Also, you don't have an automatic right to appeal the plea that you made here today. You only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. If they said no, then you wouldn't be able to go any further with that appeal. Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've discussed here in court?
No.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty to both of these charges because you are actually guilty of each of them?
Sure.
So, back on June 20th of 2025, you recall that day?
Yes, sir.
Okay. On that day, did you have an altercation with Alicia Bruce?
Yes, sir.
Is that a person that at the time that you had a dating relationship with?
Yes, sir.
Where did that incident take place?
In an apartment.
Where's that located?
131 Couple Creek Drive, Greeley.
Okay. Crawford County?
Yes, Your Honor.
Okay, and what happened that would make you guilty of assault in that case?
There was smoke. We had an argument. They were smoking in the bathroom. I tried to get in. I pushed the door harder than I should have and struck her in the face.
All right. And then another incident on October 1st of 2025, you recall that day?
Yes, Your Honor.
And on that day, did you come into contact with some law enforcement officers?
Yes, Your Honor.
Did you know that they were there doing their job or engaging in their duties as law enforcement officers?
Sure.
And what would you have done in that incident that would make you guilty of resisting or obstructing one of those officers?
I failed to open the door for them.
Okay. And they were asking you to do that as part of their investigation.
Yes, Your Honor.
Ms. Koch, would you agree that we have a factual, did that occur within Crawford County as well?
Yes, Your Honor.
Ms. Koch, are you satisfied with the factual basis as to each charge?
Yes,
Let's do that.
Yes, Your Honor.
So are the people aware of any threats, promises, or inducements other than what's been placed on the record?
no,
No, Your Honor.
And counsel, are you both satisfied that the court has complied with statute and court rule?
yes, Your Honor.
Yes, Your Honor.
Baker, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, someone from the probation department will be in touch with you for a pre-sentence report. Ms. Koch, is there anything else we need to address for the record today on your side?
No,
No, Your Honor.
All right, thank you. That's all for today. Thank you. People versus Amber Henning, file number 255443.
Sierra Coke on behalf of the people.
James Dick on behalf of Ms. Hennon, who's standing to my right, Your Honor.
Record show is present here in the courtroom today, and Mr. Dick, how did you want to proceed with this file?
Your Honor, we have a resolution to this matter. Ms. Hennon will be pleading guilty to and added count 2 of attempt resisting and obstructing in exchange for dismissal of the original count 1.
Oh, is that a correct statement of the plea offer?
It is, that is a 1-year and or $1,000 misdemeanor. The PAT code is 750.81D1. We will be dismissing the possession of methamphetamine charge based on some additional investigation that Mr. Dick has done.
Okay. Ms. Henning, have you had an adequate opportunity to go through this plea agreement with your attorney?
Yes, Your Honor.
And is that how you wanted to proceed today? Raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Ms. Henning, are you currently on any kind of probation or parole?
No, I'm not.
And as Ms. Koch indicated, the maximum possible penalty you face for this additional charge of attempted resisting or obstructing is up to 1 year, if you understand that.
Yes, I do. Your
With that in mind, what is your plea to that charge?
Honor. Guilty.
I know you sitting here and heard me go through rights with other people, but I need to go through them directly with you as well to make sure you understand. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, I do.
You understand giving up and waiving all of those rights by pleading guilty. Anybody threatened you with anything to get you to do that?
No, Your Honor.
Anybody threatened you with anything to get you to plead guilty today? Has anyone promised you anything other than what we discussed here in court? Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty?
Yes, Your Honor.
This happened back on June 28th of this year. Is that the correct date?
Yes.
And at that time, did you encounter some law enforcement officers?
Yes.
Where did that take place at?
It's at the Moton 72.
Was it here in Grayling?
Yes. I'm sorry.
Okay, that's fine. But it was here in Grayling. Okay. And did you know that those officers were there performing their duties as police officers?
Yes, Your Honor.
What did you do to attempt to resist or obstruct them in their duties that day?
They wanted me to come upstairs and I kind of freaked out and hid for a minute and then came back upstairs.
Okay, so they were there doing an investigation
Yes.
and you tried to avoid or hide from them? Presumably, was that to prevent them from being able to conduct their investigation?
It was just a reaction. Yes, Your Honor. I don't know.
Okay. Ms. Cole, are you satisfied with the factual basis?
Yes.
Mr. Dick?
May I just ask one more question? Did they call you to come upstairs?
Yes.
Did you hesitate to go upstairs?
Yes.
Thank you. Nothing for
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on record?
No.
No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in taking this plea?
Yes.
Yes, Your Honor.
Thank you. Ms. Henning, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. You're going to meet with one of the probation officers before you leave today to set up a pre-sentence interview. We'll set this for a sentencing hearing. You'll be notified of the date and time of that. You'll have a chance to go through that report with your attorney before we proceed that day. That's important that you stay in touch with him between now and then. Okay.
Okay. Thank you, Your Honor.
Thank you.
So we have two from Otsego County.
Yeah, Mr. Phillips and apparently Ms. Harriman.
So I don't see the jail connected yet from Otsego. Ms. Coke, I don't know if we can have your office,
They confirmed already the times. I will have her check on Mr. Phillips.
Okay. Take a short recess.
Yep. All right. Are you filling in for Jason or no?
Gonna go with a hard make.
Well, I mean, I didn't know if, sometimes I know you guys,
And no one has told me I am.
Yes.
Who was that?
I,
that
not
man?
without being at my desk.
Oh, that Vicky? Yeah.
I've got all the stuff written on there.
I think that was a list of extras, or maybe for parents.
She,
Parents, that's the big.
she apparently called
I
James
don't
Dick and left a
remember.
message saying that there was a big misunderstanding and this case should be dismissed.
She didn't, yeah.
Well, they were communicating. When he came in, they looked at each other googly-eyed, so.
Yeah,
is this
she
the
was
girl?
telling us things to violate it.
Is this the girlfriend?
Yeah,
So Mr. Johnson, Brandon Johnson called me on her behalf because she wants to send a letter to the judge saying this is, you know, they want to get back together, they want to be together. I said, well, you need to give me a letter. I'm like, I don't know.
That she was now dating Brandon Johnson.
I think Brandon Johnson would be a good advocate for her.
Yeah, so I talked to
Brandon
him.
Johnson?
yeah, they're dating.
Wait, what?
Brandon Johnson is now dating the victim on Baker, who wants to get back together with Baker.
It's a love triangle.
It's gonna end well when
Classic
Baker
love
gets,
triangle.
when he gets out of jail.
South side, Greenland, love
Well,
triangle. Cobble
Brandon
Creek.
should be here tomorrow for court.
Good.
That's the Cobble Creek, Lawn Deal, love triangle.
So, I mean, that was my conversation with him last week, is whatever, and he was supposed to be bringing me a letter, which I've yet to see. Or he's bringing me a letter she's supposedly writing. I don't know. I don't even know
No,
anymore.
Brandon's. I'm straighting Brandon out here. Brandon's got his own troubles. He doesn't need to get involved in anything else.
That must be why Elisa didn't speak to me. She was sitting over there with her parents,
She's
so
sitting on
usually
that side of the
she
aisle.
does talk to me.
Come on. Are they the only two left on a writ?
Ritz, probably.
So Leland and James are lodged here. Well, I need Mr. Thompson. As I was asking if you were filling in for him. If you were, I'd be like, great, so we'll just go bring them.
Ready for action.
What's your job?
I always joke, I have two dogs, one potential energy, one kinetic. Like science in motion.
We will ask Rachel if Otsego confirm Jody Phillips.
Yep.
I don't want to leave in case the judge comes back.
That's fine.
As soon as I walk out, there was like, oh, the judge is returned.
Yeah, and then neither, and Otsego's not on yet.
What time is it?
What time's what?
No, like the present time of day.
2:38. Like, is that a trick question? Is the clock not working?
Did Harriman,
No,
did Harriman get convicted for delivering that?
Yeah.
On the B grid?
One delivery, one possession. You give me that look like this is somehow on me.
Yes.
I'm used to it. I need to come up with some new ideas, how to resolve deliveries in Otsego.
Why? They only get 30 days.
That is far from the norm. Current circumstances are very.
Did you bring one for the rest of us?
Wouldn't even know how, what you would even want.
Gummy bears.
Rachel said yes, they confirmed.
Okay. I don't know where they are though.
Zero on fennel, is the sobriety court part of the plea, like, I guess I'm not 100% sure on that,
I don't know how that works now that we have that new transfer.
but that's
rule.
part of the deal.
Yeah, he's already been accepted. He's actually already started it.
Is it for this case though?
Well, he's
Yeah.
on district court probation, and he's doing it for that too.
What I'm asking is, it's a mandatory 30 days unless he's in treatment court. Is
Right.
this something we should be, are you on board with him? Just
We have the jail on.
sobriety court?
I
So it's kind
personally,
of thrown in there. Usually it's like, okay, here's the plea deal. He does this, he gets this. I know there's no reduction. So is the sobriety court anything even to do with the plea? Or is it
yeah,
just?
I mean, he's getting sentenced into it, but if you want to do jail up front for a fourth OWI, I have always thought that was appropriate, but
I just sent you the PSI from Harriman. I know I said I was gonna do it and I forgot to. I mean, I don't know if you care.
Don't tell them. All right, please.
Thank you, please be seated.
sure.
All right, ma'am, can you tell me your name there at the jail, please?
Angel Harriman.
Okay. Go on the record in People versus Harriman. This is file number 255417. The record should reflect Ms. Harriman's present today by video from Otsego County Jail.
Thank you, Your Honor. I do believe we have a resolution for the court whereby Ms. Harriman would be admitting to a use of methamphetamine. The principal count would be dismissed. I would also indicate to the court, she is presently under sentence in Otsego County, where she resolved 2 matters, a delivery of methamphetamine as well as a possession of methamphetamine there. I did forward to the court the PSI from Otsego County, but it has occurred to me that I believe I sent it to Ms. O'Rourke, who is out. So I just forwarded it to Ms. Nemke, but I'm assuming the court has not received it.
I did not. Did you want to move forward with sentencing on this today? Is that
I was going to propose that to the court because the PSI is about, well, her sentencing at Otsego was about 10 days ago.
Mhm.
So I mean, doing an updated PSI is really not going to provide any additional information.
Ms. Coe, what's your position?
I don't have any objection on it. She doesn't have a lengthy criminal history. And we can talk about what happened in the Otsego case. I think everybody here, Mr. Trush and I are familiar enough to discuss it.
This is a 1 year?
It is
Correct.
use of methamphetamine.
All right. Okay, well, let's get through the plea phrase and then plea phase, and then I can take a look at that PSI. since there are no guidelines, we don't have to worry about the scoring, it would just be a matter of but have enough information to determine whether additional jail time or some other sanction would be appropriate. But I'll make inquiries of counsel as we go through the hearing today on that. So, Ms. Harriman, in terms of entering the plea, do you understand the plea offer in this case?
To plead to the usage,
Correct.
yes.
Okay. And have you had an adequate opportunity to talk to your lawyer about that put you in a position as to know whether you want to accept that today or not?
Yes, Your Honor.
Did you want to go forward with that plea agreement?
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Ms. Harriman, are you, well, Mr. Trush, I'm going to ask you this. Is there any probation or parole that would be affected by the plea?
I don't believe so. This is a scenario where, effectively there's 3 arrests. I don't know what order they happen in, but frankly, I think the arrest happens after all the events.
Okay. All right, so Ms. Harriman, that means that the maximum penalty you could face in this case would be up to 1 year in jail and or a $1,000 fine. Do you understand that?
Yes, Your Honor.
With that in mind, what is your plea to that charge of use of methamphetamine?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've discussed on the record here today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty of this charge?
Yes, Your Honor.
So the charge in this case arises out of an incident back on March 15th of 2025. Is that the correct date?
I believe it is. No, because I've been clean since March of last year. Is that there should be a bunch of tests from Bear River showing that since March, I'm not sure what date, but since sometime in March, I've been completely clean. Every single week I've tested clean. So I can't confirm that that was the date because I don't remember what date in March my test started coming back clean.
Okay. Did this charge arise at some time in March of 2025 though?
It may have, yes.
Okay. Counsel, did either of you have a date other than the March 15th?
Ms. Harriman, were you arrested on 3/15/2025 in Frederick, Michigan at the B&B gas station in the vehicle with Larry Love?
Yes, yep, yes, that's correct.
And when they took you to jail, you had methamphetamine in your bra, is that correct?
Yes,
And you possessed it on that date in Frederick, or in Crawford County?
yes, that is correct. And then after that was when my test started coming back clean because that was my last arrest. Yes, okay, that makes sense. I'm sorry.
Okay, no, that's fine. Mr. Trush, are you satisfied with the factual basis or do you have additional questions?
I am satisfied.
Ms. Koch, are you aware of any threats, promises, or inducements other than what's been placed on the record?
No.
Mr. Trush?
I'm aware of none.
Ms. Koch, are you satisfied that the court has complied with statute and court rule in taking of this plea?
Yes, Your Honor.
Mr. Church.
I am satisfied.
Ms. Harriman, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. Did you hear our discussion about proceeding with sentencing here today?
Yes, I did.
So you would have the right to have a pre-sentence report prepared in this case. I do have the one that was prepared for your sentencing in front of Judge Hunter. I've had a chance to look at that as we've been going through our hearing today. Did you want to proceed with sentencing today, or did you want to have it set out?
Yes, I want to proceed with it today, Your Honor.
Ms. Coke, anything on behalf of the people today in terms of sentencing?
Your Honor, frankly, we weren't thinking we were going to go down this path with this case because I understand the HIP guidelines in her delivery of meth case were 24 to 40. She was given 30 days in jail with an additional 11 months of work camp on that case, which was a significant downward departure. This case happened second in time, but she hadn't been arrested yet. I think that a 30 or 60-day sentence on this case is appropriate. She was going through a very tough time in her life. She tried to hide the methamphetamine. I hope she is successful with the break that she received in her Otsego case. Thank you.
Mr. Church.
Thank you, Your Honor. I agree with the prosecutor. I don't think either of us thought that we were going to be in this position. We had discussed, and frankly, we thought it was likely that this case was going to wind up dismissed pending the outcome in Otsego. Frankly, that sentencing, while I was hopeful there would be a downward deviation from where the guidelines were, frankly, we didn't expect that it would be quite as significant as it was. Not to say that there's not good reason for that. Frankly, I think Ms. Harriman presents very uniquely. She is 37 years old, and really with the exception of a 6-month time period, she's done everything that you would expect a successful, upstanding citizen to do. The situation that she was in, again, she was going through an incredibly difficult time. She was in an abusive relationship, and frankly, I mean, everything was just kind of falling apart around her. She got started with using as escapism to get away from just her life crumbling around her. As she's already alluded to, in basically following this arrest, so in March, she kind of got back on the horse, so to speak, and really cleaned things up and got back to doing the things that we would expect her to do. I think that was kind of the moment she realized that this has gotten out of control. She's been testing clean since then. She's been working. The sentence in Otsego County was a year in the county jail. She is eligible for work camp after 30 days in Otsego. However, we are working on figuring out what her eligibility will be, because I think at present her address is in Frederick, which I think would technically render her ineligible. However, it does sound as though they're considering allowing her to participate anyway. So I would suggest, I think what the prosecutor has outlined is fairly reasonable. 30 to 60 days would seem appropriate based on what the plea is here, what her history is, and again, just some of her unique circumstances.
Okay, thank you. Ms. Harriman, anything you wanted to say today?
Just that I do accept responsibility for my crimes completely, all of my crimes, and that I do deeply regret and apologize for my actions and the impact that it had on everyone around me, especially the community, my children.
Okay. All right, well, as I said, I've had an opportunity as we've been going through this hearing to review the PSI from your case there in Otsego County, taking that into account along with what the lawyers had to say here and yourself, recognizing that you are under sentence on those cases in Otsego County, that this is a plea to a misdemeanor. I don't think additional probation here in this case is appropriate or necessary. And I think a jail sentence in the low range, again, the court could sentence you to up to a year on this charge. I agree with the prosecutor that a 60-day sentence would be appropriate given your lack of significant prior history, given that this was part of a series of incidents that took place within a short period of time. And with the hope that there's a strong possibility of rehabilitation. So if the court is going to sentence you to 60 days in Crawford County Jail, the court is going to order that this sentence be served concurrent with your Otsego County sentence.
Just, I have 0 days of credit knowledge of her. And Mr. Trush
You know,
has
she was lodged at all.
I believe, Angel, you were lodged the night you were arrested and released the next day, correct?
Correct.
So she should have 2 days.
So credit for 1 day. The court will order a crime victim's assessment of $130, court costs of $325, attorney fees of $308 state costs, or $50 state costs, I'm sorry. This is a misdemeanor, Ms. Harriman, so you won't receive any written appellate rights as you did in your case there in Otsego County. But if you wanted to seek an appeal, you would need to file for that within the next 21 days. If you did have any questions about that, then you would be able, Mr. Trush would be able to advise you on that. Otherwise, you'll be provided with a copy of the judgment sentence in this case. Ms. Pope, anything further that we need to address from your side on this case today?
No, thank you, Your Honor.
Mr. Trush?
No, thank you.
Okay, that's all for this hearing today, Ms. Harriman. Good luck to you going forward.
Thank you.
I know, they just disconnected. I'm not sure why. Didn't get a chance to. Yeah, Mr. Poyer here, we take his case.
Well, we can address his case.
Okay. We'll go on record in People versus Joseph Poyer. This is file number 255471.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush, on behalf of Mr. Poyer.
Okay, this was set for 2:45. It's now about 3 o'clock. Have you had any contact with Mr. Poyer?
I have. I have had pretty extensive contact with Mr. Poyer via email. Admittedly, I think we talked on the phone once in the last hearing, but primarily via email. He expressed to me, well, so there are significant mental health concerns in regards to this case. Frankly, I don't think they rise to the level of getting the forensic center involved. Based on my discussions with Mr. Poyer, I think he does demonstrate an understanding of what the proceedings are for, what potential defenses are, what his maximum penalties are. And he demonstrates knowledge of the case. However, in the same breath, I mean, I've reviewed probably 200 pages of mental health records from inpatient stays that he's had and such. My last communication with him, he essentially indicated to me that he is agoraphobic and believed that that entitled him to not physically appear in the courtroom and that he would not be appearing.
Scope, would you take a position on this?
Your Honor, we would ask the court to revoke his bond for failure to appear. He has a very lengthy criminal history that involves a lot of violence. He's been to prison, I believe, for strangulation and domestic violence second. He's got several domestic violence cases, aggravated stalking, cutting phone lines, malicious destruction of property, several UDAAs, and some assaultive juvenile history as well as theft. We had a case with him where he was in a local business that he did not have permission in. We dealt with that case. It's a misdemeanor case. He was running all over Facebook looking for places to stay or something to that effect. That was provided to me. I think he is a danger to himself and others. Given his criminal history, I would ask that the court revoke his bond and that when he is brought in, that we get an address where he can receive mail if he's released from jail. He continues to give his parents' address, who he's not allowed to have contact with, as a place to get mail, despite the fact we've tried to address this. So I just asked for a bench warrant today. Thank you.
Okay. All right, given all that information, I do think it would be appropriate to vote for failure to appear here in court today. And given the potential public safety threat that he poses based on the allegations in this case and his past history. Court notes that both the charges in this case involve assaultive behavior. Given his prior criminal history, so court will order that the be revoked and that a bench warrant be issued for his arrest. We'll proceed further with Mr. Feuer's case once he's arrested and brought before the court. Ms. Koch, I don't know if your office can call the jail and not to go again. I don't know. So that.
Your Honor, and the only matter I have left is Mr. Phillips. Does the court want me to call the jail?
Yeah, great. That would be better. Yeah, thank you.
Yeah, I'm not sure.
They did say Phillips will be on next. Mr. Trush, they did confirm Phillips will be on next. They had the order reversed. So Otsego Jail is working on it.
Okay. Mr. Thompson, were you ready on Mr. James' case?
Yes, thank you.
We'll call People versus Eric James, file number 255484. Mr. James. Counsel, put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Eric James. Your Honor, this is, I believe, our first status conference with Your Honor. Mr. James is facing a charge from Montmorency County. His attorney there has just requested a competency evaluation. I think in light of that, it would be prudent to wait and see what the results of that are.
Do you know whether an order has been signed for that yet?
I don't know whether the order itself was signed. I know it's preliminary things last Friday. That was requested.
Okay.
I think we should probably order one at the same time if they're ordering one and send it to the evaluator so they're aware of both of them. Because if he comes back as not competent, we're gonna have a problem with our case. So just so that we have that information. That's my thought, but however the court wants to proceed.
Yeah, I mean, I agree for a number of reasons. I think we need to have an order signed in this case. I don't know that we need two separate evaluations done, but I think if the forensic center is aware that he has charges, I think it's in court.
Yeah, I think.
Okay, so if you can take care of that, Mr. Thompson.
Thank you.
Mr. James, did you have any questions?
I was just wondering, my attorney online.
Okay, Mr. Thompson, did you?
Yes, Mr. James is wondering if the court would consider reduction in bond. This is a serious charge. Mr. James is alleged to have been in possession of a firearm. Driving in a manner that wasn't safe. In spite of that, Your Honor, Mr. James has been doing very well. He's not on probation of any kind. It's been some time since his prior events. He has some family support. That's why he's asking for bond reduction, because he believes he has people who can help him. That he would like to remain on his medication. Be effective members of society.
So,
Your Honor, we're asking that the bond stay in place. His criminal history, I'll start there, that I have written down is 2002 home invasion third, malicious destruction of police property. 2004, delivery manufacturing less than 50 grams. 2004, strangulation. 2007, interfering. 2008, OWI. 2017, R&O. 2017, reckless driving. 2019, possession less than 25 grams. There's 2 domestic violence cases in 2019 and 20, but I can't tell the disposition of those. 2022, felony taser. 2022, defrauding an innkeeper. 2023, uttering and publishing. The facts of this case are there was a BOL for reckless driving. The officers in town saw him. He got up to 70 miles per hour driving through the town of Grayling. He flipped his car. It's easy to see on the body cam or dash cam. Right, I think it's by Dunkin' Donuts, but it's right here in the business loop. Told the officers that he wanted them to kill him. They had to tase him. He had a handgun on the driver's side of the vehicle that was found. There was a search warrant done for his blood. This was a rental car. I believe he was on bond out of Montmorency when this occurred, and his blood alcohol came back at 0.214. And I think Mr. Thompson's saying I got the location wrong. I can't. Was it by Little Caesars?
Yes.
Okay, so it was over by Little Caesars, but it was right in the town of Grayling. So I think the bond is may even be low, but it's certainly appropriate. Thank you.
Yeah, well, at the time, it's not really a justification, but at the time, I just moved up from downstate, and to get away from all that. But I've been off of my psych meds, I do psychiatric treatment and all that downstate. And I was in the process of trying to get everything moved here and get back on my medication, but I was off my medication. And like I said, I go to therapy, but ever since I've been here and been on my medication, I've been feeling, better, and it's just when I'm off my medication, it's just like, I'm a whole different person, and then, I had some drinks on, it was Lions game, and it's like, I haven't drank in a minute, and when I drank, and when I had drunk that day, it was like, I got to, I just let my emotions and my feelings get the best of me, and I kept drinking. It's not like I said, it's not no excuse, but I'm not getting the proper treatment I need in being in jail here. I do get the little Seroquel they give me, but I get the extensive amount. I just had back surgery in June of this year, and this is laying and sleeping on this concrete is messing me up. I got nerve damage on both sides of my arm. I need treatment for it. I know that I can't get here, but like I say, it's no excuse, but that's really what a lot of my problems come from, is not being on my medication or being off my medication. I had I grew up in the streets, and I came up here to get away from it. I was in the streets since I was 13. I came up here and try to get a place up here because my fiance's father stayed up in Hillman, and we moved up to Hillman, got us a little spot up here, and I tried to get away from that, but being off my medication, it didn't help, as you can see.
Right. Yeah, so I'm not gonna modify the bond at this time. I think given your past history, given the seriousness of the charges in this case, which as a fourth habitual offender make the maximum penalty for a number of the charges up to life, given the need for assessment of competency for all those reasons, I think the bond is appropriately set. So
what about cash, making it cash instead of cash insured? But I don't have nobody to sign for me. But if we can make it cash, I can, talk to my brother and try to, have him put up the money, but I can't do it because I don't have no property to put up right now. But if it was
I'm not
cash,
gonna modify it from what it is this time. So, Mr. Thompson, I'll just ask you to prepare that order. Once we have the report back, we'll set this for a hearing on the next available date. Before we do that, Mr. Trush, we do have Mr. Phillips.
You want to comment on that, which matter?
Yeah. So,
Yes.
Mr. Phillips, are you able to hear me okay?
Yes, sir.
Right. This is People versus Jody Phillips, file number 255438. The record should reflect Mr. Phillips is present today by video from Otsego County Jail. If I could have counsel put your appearances on.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Phillips.
Mr. Trush, how did we want to proceed today?
So, Your Honor, we are in receipt of an offer from the prosecutor from my discussions with Mr. Phillips. I believe he would intend to accept that offer today. That offer would contemplate a plea to count 1 with a habitual second offender notice. The second or subsequent offense, drug double, would be dismissed, as well as any other habitual offender notices.
So as a second.
Habitual second,
Okay.
not a drug double. Yes.
Right. And I say foregoing the other habituals, because in theory, he could have been charged either as a drug double or a habitual.
I just the information. I just want to make sure I'm clear on that. So that's correct, Ms. Pope.
Yes.
Mr. Phillips, were you able to hear that?
Yes, sir.
Is that the plea agreement that you've discussed with Mr. Trush? Is
Yes, it is.
that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, Mr. Phillips. You can lower your hand. Are you currently on any kind of probation or parole?
Yes, sir. Parole.
All right. So you understand that any sentence in this case would have to run consecutive to any parole violation sentence you may serve?
Yes, sir.
And you understand that because of your parole status, you would also not be entitled to any jail credit?
Yes, I do understand that.
Okay. And then as a second habitual offender, this charge, which is possession of methamphetamine, will carry with it a maximum possible penalty of up to 15 years and or a $15,000 fine. Do you understand that?
I'm not sure I do understand that. That's not what my lawyer told me. I don't think. We wouldn't. I was told 10 to 34 months.
Yeah, so that may be your guideline range or an estimate of your guideline range. I'm talking about the statutory maximum possible penalty.
Okay, then I do understand that, Your Honor. Okay.
And you understand that while your lawyer may have gone through the guidelines and may have estimated what those guidelines might be, it sounds like 10 to 34. That what I follow is the official scoring by the Department of Corrections, and that may be different than what your attorney has come up with, or it may be the same. But you understand that what your attorney has discussed with you is.
Yes, sir. Okay, I understand that.
All right. With all of that in mind, what is your plea to that charge today?
It's guilty.
All right. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we've discussed here today on the record?
no, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are actually guilty of this charge?
Oh, yes, sir.
Information I have indicates this happened back on June 28th of 2025. Is that the correct date?
Yes, sir.
On that date, were you present here in Crawford County?
I was. Yes, sir.
And while you were here in Crawford County, did you have possession of some methamphetamine?
I did. Yes, sir.
Did you know that that's what that substance was?
Yes, sir.
Did you have any legal right to have any amount of it at that time?
No, sir.
Had you previously been convicted of delivery or manufacture of a controlled substance
Yes, sir.
back in 2019?
Yes, sir.
Okay. Ms. Koch, are you satisfied with the factual basis?
Yes.
Mr. Church?
I am.
Counsel, are either of you aware of any threats, premises, or inducements other than what's been placed on the record?
No, Your Honor.
I'm aware of none.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sure.
Thank you. Mr. Phillips, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. Is Mr. Phillips going to be in Otsego County for a period of time?
Well, that's actually the next thing I was hoping to address with Your Honor.
Okay.
So, I mean, that's not entirely clear. Mr. Phillips has been accepted into the Lions Den program in Roscommon. Right now, we're going to ask Your Honor to amend his bond in such a way that would allow him to enter that program. However, in candor to the court, even if the court does this, we still have to have the bond in Otsego modified before he'd be able to actually go into the program. He is set to be before Judge Hunter, I believe, on maybe the 3rd or 4th, I think, of December, where we're hoping that we can address that in that court as well. But we would ask the court to consider modifying the bond in order to allow him in. Again, it's sort of a situation of who bows first, so to speak, but we have to start somewhere.
Judge, there's also a third component to his parole violation, I believe. So there,
The Department of Corrections does have a hold on him.
Yeah.
so even if both bonds are amended,
Okay. So Mr. Phillips, I mean, I don't know what's going to happen with your parole. I'm certainly willing to consider Lions Den or treatment as part of your sentence in this case. But I think we need to get to that sentencing hearing. So the court is not going to amend your bond at this time. The bond will remain as currently set, and we'll proceed with sentencing. And somebody from the Department of Corrections will be in touch with you to go through a pre-sentence report. Do you have any questions about that?
I don't, Your Honor, at this time.
All right. Mr. Church or Ms. Koch, anything further on this case today?
No.
No, thank you.
Okay, thank you, Mr. Phillips. We're gonna disconnect at this time.
All right, thank you, sir.
Leland, if you want to. On the record in Chico versus Kimberly Leland, this is file number 245281. If I can have counsel put your pen down.
Sierra Coke on behalf of the people.
Thank you, Honor. Jason Thompson. on behalf of the defendant.
This is the date and time set for sentencing in this matter. Ms. Leland, have you had a chance to go through the pre-sentence report and talk to Mr. Thompson about that?
No, I haven't talked to him. I read it.
Like to do that before we proceed today?
We're prepared, yeah.
Okay. Mr. Thompson, are there any additions, deletions, or corrections to that report?
There are not here.
Challenges to the scoring of the guidelines?
No, yeah.
Ms. Koch, do the people have any additions, deletions, or corrections?
No, Your Honor.
Challenges to the scoring?
No, Your Honor.
Anything on behalf of people for allocation?
Your Honor, Miss Leland was in a vehicle. I don't remember the exact amount, but it was like hundreds of grams of methamphetamine. They belonged, according to her, what she stated at her plea, to her husband. Her criminal history is relatively small. She has 2 misdemeanors. She is eligible for 7411. The guidelines are 0 to 11. We did have some issues with her failure to appear throughout this case, but I do think the recommendation is appropriate. I hope I'm not wrong in that. I hope that she follows her probation and takes advantage of that 7411 and maybe gets her life back on track before it gets completely out of control. Thank you.
Mr. Thompson.
Thank you, Anna. We do agree with the recommendation. I think 7411 is appropriate. I think defendants, generally speaking, under law are entitled to one, opportunity to show that this is something they can put behind them. And I think Ms. Leland's entitled to that opportunity, and I am hopeful that she can put this behind her. She had some for personal use, the courts where their husband's got a bigger case and a bigger problem because of what he had in the car. But I think it's an appropriate recommendation. She has been in for 37 days. So I think she has received a punishment on this. And I think, we will see if she is successful in her probation. If she is, she should get the benefit of the 7411. And if not, she'll have to face your honor again. Thank you.
Ms. Leland, anything you wanted to say? I did read through the report, so your background and your circumstances based on the information in that report. I'm also familiar with what happened in this case based on that as well. It sounds like you've been battling some substance use issues for a long time, but you managed to not get involved in the criminal justice system despite that. This case, of course, really exposed you to a lot of trouble. I remember the amount because I read it and I was shocked. 324 grams of methamphetamine, that's almost 3/4 of a pound. That's a huge amount. And, to just be driving on the highway with that amount of drugs in your vehicle with you, sounds like this was just a freak accident. Went off the highway, rolled over, police showed up, and all of this got discovered. So who knows how many of those other trips you've made like that where you didn't go in the ditch and roll over. Be that as it may, I always view 7411 as an opportunity for you to have this come off your record if you successfully complete probation. There's really no downside to the court or the community in giving you that chance. And I do hope that you're successful with it because you don't have much of a criminal history. And if you can follow the conditions of your probation and you're successful, then you'll get the benefit of that. And if you don't, then time will tell and we'll be back. But I hope that you do. I think given your lack of prior criminal history, given at least based on the plea in your testimony, that your involvement in a large amount of drugs was minimal, I think the recommendation is appropriate. I'm going to follow that. So the court is going to sentence you to probation for 24 months pursuant to 7411. The court is going to adopt as the conditions of your probation all the terms and conditions listed in the report. So it's important that you go through that with your probation agents, as you know, all the restrictions that you're going to be under for the next 24 months. Court is going to impose 37 days in the Crawford County Jail. Credit for 37 days served. Crime victims assessment of $130. Court costs of $325. Attorney fees of $350. DNA testing fee of $60, $68 state cost, the crime victims assessment of, and a supervision fee of $30 per month while you're on probation. Because this is pursuant to 7411, there are no appellate rights at this time. And Mr. McDowell, I'm assuming this will transfer to downstate supervision.
I'm gonna talk to her in the back hall and get this squared away.
Okay, so Mr. McDowell is gonna help you get everything set with your probation and good luck going forward.
And it'll just take a little time to process.
justice. So.
All right. Okay.
Okay. Versus Brett Dooley, file number 255458.
Sierra Coke on behalf of the people.
Right.
Good afternoon, Judge Jared Shuey on behalf of Mr. Dooley, who's present with me on court.
Thank you. This is the date and time set for sentencing in this matter. Mr. Dooley, have you had an opportunity to go through the pre-sentence report and talk to Mr. Shuey about that?
Yes, Your Honor.
Mr. Shuey, are there any additions, deletions, or corrections that need to be made to that report?
There are none, Your Honor.
Are there any challenges to the scoring of the guidelines?
We do not have any challenges, Your Honor.
This vote
No, Your Honor.
challenges to the scoring
No.
on behalf of people who are allegations.
Mr. Dooley, you know, by all accounts, is a productive member of society. He is a mechanical engineer. He has a good job. He has no juvenile record, no misdemeanors, no felonies. I have no idea how someone with, you know, that makes it 24 years with no interaction at all with the criminal justice system ends up driving at a 0.248, increasing his speed to 90 miles an hour, gets into a fight with the officer, slips the cuffs. This is crazy. This is one bad night gone really, really bad for him. I understand the recommendation and why it's so low in this case, and it's because of his criminal history or lack thereof. I hope that he takes this really seriously and that this has some effect on his life, because this is just a terrible set of circumstances. Thank you.
Yes, Your Honor. To start out, I do have some proof that Mr. Dooley's been attending AA, if Your Honor would be willing to review that.
Sure. If you can
Also a few letters of just character letters from people that Mr. Dooley works with, if Your Honor would be willing to review that.
Yes. I'll do that as you continue with your allocation.
All right, thank you, Your Honor. I would agree with Ms. Cope that it's hard to imagine why Mr. Dooley did these things that night, and obviously, I think the obvious answer is alcohol. I mean, when somebody consumes that much alcohol, they do things that are out of character, and Mr. Dooley obviously was out of character that night. If you read those letters, Your Honor, you'll see that he is a productive individual that is well respected at where he works. He's had a good record. He has a good job. He does not take that for granted. And he's taken this very serious. These events that have led up to why he's in this court. You know that he's been addressing his alcohol consumption, and that possibility of having some type of problem with alcohol to be able to drink that much. But again, I just don't think it's rocket science, Your Honor. When somebody drinks that much, they do things that they don't normally do. They do stupid things, and they make poor decisions. And of course, these ones were against the laws in the state of Michigan. Mr. Dooley is the first to admit that that leads to consequences in his life. And that's why he's here. He's come to every court hearing. He's flown in from Maine. He lives in Maine. He is trying to address this and do the right thing, even though he did all the wrong things that night. And do the right thing for this forward. The pre-sentence investigation made a recommendation of not any probation, considering the fact that he not only lives in Maine, but that he's on a ship on a regular basis, works for Grand River Navigation. So we would ask that you would consider that. I know that there's some jail time recommendation there of 15 days. Of course, we would ask for no jail time, but I know that Mr. Dooley is prepared to whatever this court is requiring him to do today. He does have some time off right now. He's prepared to serve whatever time that he has to. But considering his record, considering how he's taken this serious, Your Honor, I know that it's probably a struggle to allow Mr. Dooley to leave here with just fines and fees with such a serious incident to happen. But I can tell you, Mr. Dooley would never think that this just a slap on the wrist and that he's going to continue to do this. He's got other collateral consequences. He has to many times have to be in the country of Canada. Obviously, a felony on his record is going to present hurdles and problems for him with that. And again, nobody's fault but his own, and he understands that. But there are some serious things that he has to deal with, no matter what Your Honor decides to do with him today. He's going to have to deal with for the rest of his life, because until he gets it expunged, he's going to have this serious crime on his record. So I know he's prepared to pay any fines and fees today, I believe. And I think that again shows you some responsibility on his part to be prepared for whatever consequences that are enacted today. So we would just respectfully ask that you take that all into consideration before sentencing Mr. Dooley. Thank you.
Who's got the phone? Ryan, can you just go out until you get that squared away for me, please?
I'm sorry, I'm trying to turn it off.
Yeah.
I apologize.
That's all right. Maybe if you think you have it now.
Yeah, I think so. I'm trying to get my watch off.
Why don't you go out in the hallway?
I will, I apologize.
Sorry about that, Mr. Dooley. Anything that you wanted to say?
I'd like to start off by saying thank you all for your time today. The evening of August 7th was a collection of very poor choices by me that were fueled by alcohol, but that is no excuse for them. I understand that the charges are very serious, and not only did I put myself at risk that night, I put everyone's safety and well-being around me as well. And for that, I am very sorry. I hope between the letters and what Mr. Shuey has said here today, I hope it is apparent that this is a one-off thing for me. While serious, I do intend to continue going to the AA meetings. I got a good group at home, and while I am home, I will continue to go to that and take my sobriety seriously to ensure that this kind of thing never happens again.
Well, I did read through the report, so I'm familiar with what happened in this circumstance. There's also a lot of information in there about you, your history, and your background, and so forth. I had a chance to kind of look at these real quick here. Yeah, certainly the letters are complimentary of you and the type of employee that you are, dependable. You have so much going for you that to have something like this occur in the first place and to not take it seriously would be a real tragedy on your part, because I think anybody who ends up with a substance use problem, you can always trace it back to little things that happened early on, and then they start to snowball if you don't get a hold of it. And this is one of those things. I mean, we can look at it, oh, this is a one-time thing, it'll never happen again. It can also be a sign to you that there are some cracks in the armor that you need to address. And I'm glad to see that you're going to AA. I hope that you do continue with that, because generally when something like this happens, it is an indicator of something else going on that needs to be addressed. Otherwise, it wouldn't have happened at all. A lot of people are able use alcohol their entire life, and never have something like this happen. So I hope you take it seriously. I hope you do get help. Whether you think you need it or not, get that help. It's not gonna hurt you. And like I said, you have way too much going for you. You've got a really interesting, marketable career that I would assume is really lucrative. Probably live a really comfortable, really interesting life. And I don't want this for not doing that. There's not many people at 24 years old that have as much going for them as you do. So I hope that you do move on from this. What happened here is definitely frightening. We could be here for a completely different reason right now. Given your lack of prior criminal history, I think 15 days in jail is a good wake-up call for you. I think 15 days is going to have just as much of an effect as 30 days would, or 60 days on somebody who's never really spent time in jail. I think it's going to be a wake-up call for you and give you a view of what waits for you if you don't continue to get help. So I think it's an appropriate penalty. I think it provides a degree of punishment for you. And I think it's also recognizing all the mitigating factors that we have. So the court is going to sentence you to 15 days in the Crawford County Jail. You do have credit for 2 days served. Crime victims assessment of $130, court costs of $325, fine of $500, DNA testing fee of $60, $118 state cost, and the OEYO reimbursement fee of $150. You do have the ability to seek an appeal of the sentence, Mr. Shuey. We have the appellate rights on that table there. You can have Mr. Dooley just initial acknowledge receipt of those.
You might have to dig, there's several match the name. The top portion of that, yep, that was going to come to me, 2 copies to him, and 1 copy to me.
One copy to.
Shoot at him, 1 to the prosecutor.
Thank you.
What's going forward? Certain. All right, people versus Daniel Knight, file number 55433.
Sierra Coke on behalf of the people.
Jim, on behalf of Dan Knight, Your Honor.
Record should reflect Mr. Knight's present here in the courtroom. This is the date and time set for sentencing in this matter. Mr. Knight, you have an opportunity to go through the pre-sentence report and talk to Mr. Knight about that.
Yes, Your Honor.
Are there any additions, deletions, or corrections to that?
No, I don't believe so, Your Honor.
Have any challenges to the scoring of the guidelines?
No, Your Honor, I believe the scoring was correct, but I'll address that issue in my allocution.
Oh, Ms. Koch, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation today?
Your Honor, I think the recommendation is appropriate. He doesn't have very much of a criminal history. He has some things going on in Antrim County, but those are just pending right now. Based on this case and what happened in this case, I think the recommendation is appropriate. Thank you.
Your Honor, again, I don't believe the scoring was incorrect. The issue that I have is the additional jail time, which is being recommended, obviously, because of guidelines. My client, as you know, has 2 different diagnoses here that he's dealing with. One is psychosis,
When he was in the Antrim County Jail, and it's reflected in here, one of the issues that came up was his competency to stand trial. And that was brought up not by me because I wasn't involved in the case at that stage. It was based upon the prosecution's view of him and some of the statements that he was making. He had been previously treated at McLaren Hospital in Michigan. Upon his release, after he was found competent, he went back to McLaren for a period of time to make sure that he had this problem at least under control as much as he could. He is still being treated for that. You'll notice there are 4 different medications that he's on at the present time to deal with the psychosis. He's keeping in regular contact with his doctor for that. He also found out that he has a seizure disorder as well. And one of the things that he mentioned to the probation officer in the pre-sentence investigation was the fact that he believed he was he called it a fugue state. He was not really aware of where he was, what had happened. He's indicated to me and to the probation officer that he didn't recall anything the day before or the day of this incident. He had no reason to be driving the vehicle that day. He had no reason to be coming to Grayling for any reason. And he has no idea why he was driving the vehicle to begin with. He doesn't have any driving privileges at the present time for 2 reasons. Number one, there was an implied consent suspension. And secondly, as you're aware, if there are seizures, the doctor is required to report that to the Secretary of State. And there has to be at least 6 months of being seizure free before they will even consider trying to give him a license back again. He understands that and accepts that. He's not concerned about driving at this point. Unfortunately, what that does is put his parents in a situation where they have to transport him. And they've done that since the time of this incident. So he's trying to take care of the problem. I know that the reason that he scores 5 to 23 was because he entered a plea in Antrim County prior to the time that he entered a plea here, which showed 2 prior convictions, and that gave him 20 points, which raised the guidelines to 5 to 23. Because if he wouldn't have done that, he would have been 0 to 9, as I believe you're aware. He's already served 68 days in jail. And the issue is whether or not additional jail time is really going to make a difference in his attitude, in his progress that he's been making with the psychosis. And I think it's probably more likely to be a setback, if anything else. He's been testing for 10 months for drugs. There has not been a positive test the entire period of time. So he's obviously dealing with that problem, I believe. And again, you know, the tests are given, I think, for a month random drug test. And he's, like I said, he's been on that since the time that he was released from jail in Antrim County. I think he's trying to make a legitimate effort to make sure that any mental health or I guess seizure problem does not put him in this situation again at all. He is scheduled for sentencing in Antrim County, I believe now on, I think it's the 16th, December 16th. So they obviously have a big hammer on him over there too, based upon the charges that he has. I think that Dan's a smart person. He obviously has a master's degree. He was in counseling before counseling other people. And obviously would like to get back in that situation. Unfortunately, at this point, he's not able to do that, but that's his goal, is get back to being a productive individual and working again. But until he gets these problems cleared, not only the criminal problems, but his health problems, I don't think that's likely to occur. But as far as the recommendation is concerned of additional probation to have him prove to the court that he can stay clean, I don't believe that's a problem at all. I think he can do that without any problem whatsoever. The question is whether or not the additional jail time, which is basically giving him the same amount of jail time that he's already served again on top of it, whether or not that's either going to be a deterrent to him at all, or whether or not it's the appropriate punishment. I think when you take into account all of the circumstances of why he's here and what he's suffering from, that additional jail time really isn't necessary.
All right, thank you, Mr. Knight. Anything you wanted to say?
No, that was very well said. Thank you, Jeff.
I did read through the report, so I'm familiar with your background and your circumstances, as well as what happened in this particular case. So I take all of that into consideration, try and craft a sentence that recognizes the mitigating factors, which I think there are some mitigating factors here. Number one, I think the potential for rehabilitation is certainly there. Given your level of education, given your prior career, and I think it's certainly possible and hopeful that you're going to get back to that once you address your underlying issues. So all of that gives the court some reason to believe that rehabilitation is certainly an aspect that needs to be looked at and a mitigating factor here. I also think, though, that the court has to look at what happened here, which is you put yourself in danger, you put a lot of other innocent people who were on the road that day in danger. And had you caused an accident, injured or killed somebody else, they or their families really wouldn't care what your underlying issues were. All they know is that they've been harmed by you. And I think all of them would probably make an argument that, you know, put yourself in that position, you took the substances that you took, and that caused you to do what you did. And so I think there's a price that needs to be paid for that. And I think you need to understand that if you don't manage your underlying problems, where you take substances that are going to put you into this state, that you're going to face more than just probation. Hopefully that provides a deterrent effect. The recommendation is at the very low end of the guidelines. I don't see any reason to go below the guidelines in this case. I think the recommendation is really well crafted to address both the upside potential for rehabilitation here, but also a penalty and hopefully a deterrent to motivate you to manage your underlying conditions so that you don't put yourself in a position where you're going to hurt or injure someone else or yourself. So the court is going to follow the recommendation. The court is going to sentence you to probation for a period of 18 months. The court is going to adopt as the terms and conditions of your probation all the terms and conditions listed in the report. The court is going to order a restitution in the amount of $150 for OUID testing, a crime victim's assessment of $130, court costs of $325, fine of $500, the DNA testing fee of $60, $68 state cost. While you're on probation, a $30 supervision per month. Court is going to order that you serve 5 months in the Crawford County Jail. You do have credit for 68 days served. You do have the ability to seek an appeal of this sentence. Mr. Hunt was to tolerate. Have Mr. Knight acknowledge receipt.
Thank you, sorry. Your Honor, for the record, my client is signing while initial the date of the form.
Mr. Knight, you are admitted to the custody of the county.
Thank you, Your Honor.
forward. Mr. Thompson, do you know Miss Moore's whereabouts?
Yes, she's in rehab. We had sent the court a request to appear via Zoom.
If you have some contact information, you might have to give her a call because she's not on the Zoom page yet.
Okay, I'll be right out. Thank you. Contest, I have the report. She was pretty drunk.
Yeah, no, that sounds.
All right, Ms. Moore, are you able to hear me okay?
Yes, I am. Are you able to hear me?
I can, thank you. All right, we'll go on the record in People versus Tammy Moore. This is file number 255490. The record should reflect Ms. Moore's present today by video by prior approval of the court. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Tammy Moore.
And Mr. Thompson, how do we want to proceed with Ms. Moore's case today?
Your Honor, we do have a plea offer in this case. Ms. Moore wanted to accept that on a no contest basis due to intoxication. The plea offer, if Ms. Moore pled guilty to count 1, assaulting, resisting, or obstructing a police officer, a 2-year felony, as well as count 2, misdemeanor retail fraud in the 3rd degree. The prosecutor would agree to dismiss the habitual offender notice and agree to dismiss count 3, which was disorderly drunk.
Ms. Coke, is that a correct statement of the plea offer?
Yes.
Ms. Moore, were you able to hear that?
Yes, I was.
Ms. Moore, are you able to hear me?
What happened?
We can hear you again, Ms. Moore.
There we go.
Okay, thank you. I
Why
don't
don't
know.
you,
It's the location I'm at.
Yeah, why don't you turn off your video?
I'm sorry.
Turn off your video.
Okay. How do I do that?
If you touch your screen, then on the bottom of the screen, there should be something that looks like a movie, like a movie camera. If you press that, a red line will come through it. you touch your screen.
Okay. It's not showing that.
All right, that's all right. We'll try it. Sometimes if you
Okay.
turn off the camera, it helps when you're in a bad area because you don't use as much bandwidth, but. we'll try
Okay.
it. Were you able to hear what Mr. Thompson said about the plea agreement?
Yes, I was. I did. I heard what he said.
Is that how you want to proceed today?
Yes, I do. I want to see no contest.
Okay. All right, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Ms. Moore, are you currently on any kind of probation or parole?
No, I'm not. I just graduated from a rehab called Meridian, and I'm in another one now. And it's a long-term it's as long as I choose to be here. It could be up to like 3 years, but I can be here even longer than that, as long as I'm doing good.
Okay. All right, so you're going to be pleading guilty to one count of resisting or obstructing a police officer. That carries with it a maximum possible penalty of up to 2 years and or a $2,000 fine. Do you understand that?
Yes, Your Honor.
And one count of retail fraud, third degree, which is a misdemeanor, that carries with it a maximum penalty of up to 93 days and or a $500 fine or 3 times the value of the property that was stolen. Do you understand that?
Yes, Your Honor.
And with those maximum possible penalties in mind, you indicated that you want to enter a plea of no contest today. Is that correct?
Yes, Your Honor. Because I don't even remember anything that happened that night because of due to my my alcohol.
Okay. All right. So I'm going to go through a few things with you regarding your rights. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Mm-hmm. Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading no contest?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. If they said no, that would be the end of your appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty, no contest?
No, Your Honor.
Has anyone promised you anything other than what we've said here on the record today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
All right, I'm in possession of Crawford, Grayling, Public Safety Department, report number 25-912. Ms. Koch, have you reviewed that police report?
Yes.
It's 3 pages. Would you agree that the information contained within that report would provide a factual basis for both of the charges here?
Yes.
Mr. Thompson?
I would agree.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No.
Mr. Thompson?
No.
And Ms. Koch, are you satisfied that the court has complied with statute, court rule, and the taking of this no contest?
Yes, Your Honor.
Yes.
All right. Ms. Moore, the court finds that your plea is knowing and voluntary. I reviewed that police report, which I'm going to mark and admit as Court Exhibit 1. I would agree that the information contained within that report indicates that you had a level of intoxication that would support the no contest plea, and that the facts contained within that report would support a finding that you are guilty of counts 1, count 2. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing.
I'm in a recovery house, like I said, and I was wondering, I know I have to show up in person, but I was wondering, am I going to have to do the jail time, or how is that gonna work?
I
Am
really
I gonna
don't know.
have to leave this program?
What's going to happen between now and your sentencing date is somebody from the Department of Corrections Probation is going to be in touch with you. They're going to prepare a pre-sentence report. So I don't know what the recommendations are going to be. I don't know what your guidelines are going to be. And I really, sitting here, I don't have any information about you or your circumstances, and I'm going to get all of that from that report. And that's how I determine what an appropriate sentence is. So I can't tell you here today what that's going to involve. But you are correct. You will need to make arrangements to come here to court for that sentencing hearing.
Okay.
Do you have a phone number at that facility where you're at, where the probation officer can contact you?
Yeah, my lawyer has it.
Okay, can you provide that to Mr.?
Do you have it? Can she just provide it?
It's in
Judge,
my
so
office.
we're clear.
Do you have it with you there?
No, sorry.
I have to go get it. I don't know it by heart.
What's the area code, Tammy?
989.
I don't have it on me, Your Honor. I'm sorry.
Okay, can you go get
It's on my
that?
phone, which
Ms.
is
Moore?
power. What? Sorry, my phone died. It's where it is.
I'll just see what that. Then we still have it after court. That's very helpful.
What's the facility she's at?
Meridian.
It is 989 755 7538.
Okay, so it's important that you follow up with the probation officer when he contacts you, okay?
Is there a number? Is there a number for them?
I'm gonna text it to that phone right now. Okay, I'll text my business. I'm gonna text my business card to your phone right now. Okay.
This is a house phone.
Oh, okay. Yeah. Can I give you my number?
Yes.
Ready? 989.
Yes.
254-3181. That's my work cell number.
254. What is the last four?
3181.
3181. Okay.
Okay, do you have any other questions, Ms. Moore?
No, I don't.
Okay, that's all for today. Thank you. The court's going to disconnect at this time. That also concludes our afternoon docket. We'll be in recess for the day.